In this video, we will look at Order 6 of the Civil Procedure Code. Order 6 talks about pleadings. In this video, we will look at an introduction to pleadings. What are pleadings? Order 6 Rule 1 defines pleadings as your plaint and your written statement. Order 6 can be divided, the rules in Order 6 can be divided into the following. Rule 1 talks about the definition of pleadings. Rule 2 talks about the fundamental principles of pleadings. Rules 3 to 13 talk about what parties need to write in their pleadings. The necessary, the necessary particulars which parties must plead in their pleadings. Rule 14 and 15 talk about signature and verification of pleadings. Rule 16 talks about the power of the court to strike out unnecessary pleadings. And Rule 17 and 18 talk about amendment of pleadings. Now, it is well settled law that in the absence of pleadings, the parties, if they lead evidence in the absence of pleadings, that evidence will not be considered. It is also well settled that no party shall be permitted to travel beyond its pleadings, and all necessary and material facts should be pleaded by a party in support of its case. Now, why do you require this? You require this because the other party, the opposite party, should know what your case is about. It should be able to defend itself. It should not be subjected to surprises. Only then will a fair trial be conducted. Now, this is well settled law. But in this particular case heard by the Supreme Court, that is Ram Sarup Gupta and versus Bishun, Narain, Inter College and others in 1987, this particular case stated that it's not necessary that a court should look strictly at the form of pleadings. A court can also consider it should consider the substance of pleadings. So Ram Sarup Gupta, this case law held that pleadings should receive a liberal construction. Meaning sometimes pleadings are expressed in words which may not expressly make out a case in accordance with the interpretation of law. In such a case, it is the duty of the court to ascertain the substance of the pleading to determine the questions at hand. Now, once it is found that in spite of deficiency of pleadings, the parties knew the case and they laid evidence on that case, then they could not take the defense that, there's a deficiency in the pleadings when they are going in for an appeal.